Get ready for the dictation. Start. Since at the stage of preliminary hearing, we were inclined to hear the entire writ petition, the application was not pressed. However, because a final hearing has not so far happened, we have taken up this application for interim relief. Mr. Nath, London Counsel for the petitioner, submits that respondent number 2, who has been appointed as the Vice Chancellor of respondent number 1, suffers from various inherent disqualifications which were not brought to the notice of the learned Lieutenant Governor of Delhi, who passed the order of appointment dated 26/9/2018. Even otherwise, he should not be allowed to function during the pendency of the writ petition when the matter of his disqualification is being considered. Respondent number 1, Netaji Subhas Institute of Technology NSIT was declared to be deemed university by notification dated 1/8/2018. Consequently, relying upon section 46 of the Delhi Netaji Subhas University of Technology Act 2017, respondent number 2, who was then functioning as a director of the institution, was appointed as the first Vice Chancellor of the university. To appreciate the submission of Mr. Nath, we deem it appropriate to reproduce section 46 of the Act, which reads as under. Transitional provisions notwithstanding anything contained in the Act and the statutes, the first Vice Chancellor, the first Registrar and Controller of Finance shall be appointed by the Chancellor, and they shall be governed by the terms and conditions of service specified by the statutes. The first court and the first board of management shall be nominated by the Chancellor and shall hold office for a term of 3 years. Mr. Nath submits that although the appointment of the first Vice Chancellor, the first Registrar and Controller of Finance is to be made keeping in mind the transitional provisions, but the power to make such appointment could not have been exercised in an arbitrary manner. In the case of the first Vice Chancellor, the appointment came to be made whereby only one name was recommended and accepted by the Lieutenant Governor. At best, this provision is to be read with the intent to avoid delay of appointments, advertisement and other lengthy procedures. But even if some elaborate procedures could have been given a go by, the petitioner contends that respondent number 2 should not have been appointed in the manner he has been appointed. Mr. Nath has placed reliance on a decision rendered by the Apex Court in the case of Ram Tawakya Singh versus State of Bihar and others, reported as 2013-16 SCC 206, more particularly paragraphs 38, 39 and 40 in the judgment dealing with the provision of section 10 of the Bihar State Universities Act, which is in pari materia with the provision under reference. In these proceedings, the Supreme Court has observed that even where no specific procedure is contemplated, some mechanism must be followed and a panel be prepared for persons of eminence for making appointment to the post of Vice Chancellor. In our view, this submission of Mr. Nath requires consideration, namely as to whether it is permissible and in public interest that a single name be sent for consideration before the Lieutenant Governor, or should at least a pool of names of eligible candidates have been sent for the Lieutenant Governor to have some options to compare and choose from and what should have been the procedure adopted. Mr. Sanjay Jain, learned ASG, has produced the original file and it has been urged by him that the appointment was in accordance with law, and respondent number 2, being a person of eminence who was already heading the same institution, was most suited and was duly appointed. At this stage, the question arises for our consideration is as to whether respondent number 2 should be allowed to continue in the position till the writ petition is heard and finally decided. Mr. Nath has strongly urged before us that the appointment of respondent number 2 suffers from the following disqualifications. Stop.